Man, you weren't even giving up your phone number. What? Well, I'm gonna let the powers that be know he wouldn't cover his client. Client was just looking for somebody to call. I'm just gonna say. You know, when he said, "Can I say so?" I was just hoping. I thought it would be just something. Didn't know it was going to be all that. Court calls the case People versus Zion Jones.
Good afternoon, people.
Ready, Judge. Torture Police Assistant Public Defender on behalf of Mr. Zion Jones, who is not present, but I know where he is. If I may.
Hey, you want to share that with the rest of us?
Yes, Judge. I got a text message from our office this morning.
If he's on a bus, I don't want to hear.
Not on a bus.
All right.
So apparently he bonded out of jail yesterday, went to work. He works on the line and he injured his leg. He's at St. Joe's Hospital. So we asked him to get proof of his hospital visit, and we're asking for a brief adjournment so he can come next week or the week after, whenever the court's pleasure is. But he's at the hospital.
So he got out of jail, went to work, hurt his leg, and now at the hospital.
Yes, Judge.
Ms. Zender, why'd you wave your head like? Wow.
And I called him to verify. He answered. I said, "I'm at the hospital. I'm getting a letter. I'll bring it when I leave." So.
Can you request a 48-hour bench for the defense failure to appear? I would just like to
Why would we do that?
To give him time.
He has a whole story.
I will take Mr. Feaster at his word. I trust.
Okay, then.
I would also just represent, similar to the co-defendant, I am preparing an amended complaint with the added count of assault with intent to commit robbery while armed. And
This was the one that you're trying to up the bond on, and
that is correct, Your Honor.
Feaster?
So, Judge, I would ask that the court not up his bond until that is actually filed.
I'm not going to up his bond at this time because I need the amended complaint. I don't have that. But.
And I will forward the court and the cook the hospital letter as soon as I receive it this afternoon, Your Honor.
August 14th, I'm 1 week.
Thank you, Judge.
I'll adjourn it out based on that story you gave me.
Thank you so much. And I will get the proof.
And if he doesn't show up,
I understand.
I'm going to issue a bench warrant and take you in.
No, I don't understand that.
No, that's the way it works.
I will.
You want me to go with the story? That's how it's going to work.
What? You can issue the bench warrant today, then, Judge. I don't want my freedom tied to his. Thank you, Judge.
You're welcome. Court calls the case, people.
Quick question for the audience. Should tenants still pay full rent if their basic trash service isn't even possible? Notice how respectful the tenant is here?
You may be
He's
seated.
calm, logical. Honestly, would you stay that patient after months of hauling your own trash?
Yeah, let me do that. Where's the number? Okay, that's right. Yeah. Court recalls the case People versus Olin Thurman.
Allie Zend on behalf of the people, Your Honor.
Assistant Public Defender Alexis Erupts on behalf of Mr. Thurman, who's approaching.
Olin Thurman.
Okay. Record should reflect prior to the system going down that we were having a bench conference. We concluded that bench conference. Fundamentally, the defendant was released to a particular address on a tether. That address is no longer available to him. He, in a nutshell, has a place which he can be released to. However, his release to that place would be in violation of his current body conditions.
Yes, Your Honor.
Even if there's somebody there. Even if there's somebody there.
Your Honor, and just to further, he doesn't have any other location to go. It is my understanding that there'll always be some other adult present at that location. Even when the mother's children does go to work, her parents come to watch the children while she's at work. So if the court's concerned, we would ask for that bond condition to be modified to say no children except his own children. Like Your Honor is aware, they are his children, and the mother is present in court and is willing to.
Right. I understand, but with reference to the primary case, his release, his contact with his own children of that other relationship is only supervised, right? So and I get why you may be asking, but what you're in effect asking the court to do is then to release him in the presence of kids unsupervised.
Well, Your Honor, it's my understanding that there will always be someone else at the home while the children are present.
Yes, and I get that. I'm saying it's not a structured supervision under sort of some type of monitoring. I get what you're saying. And I'm uncomfortable doing that. Young man, you don't have any other place that you could stay?
No, sir.
Okay, because here's the problem. I'm gonna do this in a way to try to be fair, because he's come here, he said what his circumstance is. He's been released, can't go back to the place that he was. Has tried to find, in good faith, I think, alternative living arrangements. And so I'm not faulting him for that. I just think that releasing him to that would be in violation of his current bond conditions. When I look at the bond conditions, the charges, I think that those bond conditions are appropriate. And so I'm not going to even modify or tweak those bond conditions. In this case, I don't know enough to do that, first of all. But I also want to be fair to the defendant. So what I'm going to do, counsel, is I'm going to pass this to my 3 o'clock block.
Okay.
Give you an opportunity to try to find some other alternative in doing that. I think that's probably the best I'm going to do. I'm in effect, really what I'm doing is I'm resisting putting him back in. I'm going to give you a chance to kind of brainstorm, figure out something else before I'd have to come to that point. Okay.
Understood, Your Honor.
Okay. So we'll pass this to the 3 o'clock block. My last one.
Thank you, Your Honor.
Thank you, Your Honor.
So, oh, I don't. Yeah.
That's fine.
Yeah. Okay. Court. Yeah, let's leave it out here. Court does call the case of the people versus Tamaran Jones recall, I think.
And the original good people.
Sherilyn Foster Tucker on behalf of Mr. Jones.
Mario Jones.
All right. I had given you another day, and I had bond continue. At this point, I mean, I look back, and the reason I didn't know about it is because typically, if something like this happens and there's wanting to be a change in the bond, and my staff let you know, Ms. McDuffie, we would need a motion on this to do that so one could see exactly what it was. So at this point, I'm not going to deal with any bond violations. People want me to deal with it that way. because he's got another case he's got to deal with. If they want me to deal with it that way, then they're going to have to file a motion. So I'm not going to do anything on it.
Okay. Thank you, Your Honor.
Thank you. Court does call the case of the People versus Gregory Bell.
Albert Bell on behalf of Gregory Bell. Your Honor, thank you for recalling the matter. Mr. Bell is diabetic. He had to run to get us something from the candy bar, from the vending machines. His blood sugar.
Okay, I'll call it up in the next block.
I appreciate
running
it.
behind you.
I understand. Thank you, Judge.
Gosh, yes. Ready. Here we go. I spend my life ready. You sure?
Yes, Judge.
In anticipation about what I'm going to go through right now, this is absolutely all your fault.
Oh. In anticipation.
In anticipation of it, I'm just letting you know.
Well, let me apologize in anticipation for this being my fault, Judge. I am sorry.
Court does call the case of the People versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
What?
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid.
That were going to be addressed. That would be addressed at the preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir,
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lumpy has let me know that all paper discovery had been sent to Mr. McGowan in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McGowan, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him?
I expected you would have them early next week. So if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th, and then he'd have them well in advance, and I'll do it that way. Prior to setting the preliminary examination, this being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to immobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, the location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. The court could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance, given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you.
If
That is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge Torshio Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting a release, Your Honor, PR bond.
And a response from the people regarding his bond.
People would ask the bond to continue, and he also, I'm sure, failed to appear before the judge's place. So
yes,
that warrant would also hold up with respect to the other. I'll wait. If there are pleadings filed by the defender's office, our office will respond to that. And I guess my one remaining point would be, with the court's appointment to Eastern Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still held, regardless of what the bond would. In this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
that's what I
would
Mr. Choda said.
In any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff,
I was not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital, and they later tacked on charges,
you know
just
what?
like the fleeing and eluding
will
charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for the Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people, individuals, without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
I'm aware of such note or such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I hear otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Somebody be able to continue.
Done with it. Robert. You're right. You swear to affirm the information contained in the search warrant affidavit. All right, fantastic. I will sign these and hand it right out. Okay, thank you, sir. Are they? And Mr. Priester?
I'm sorry too, Judge.
No. You know, I'm just gonna say sometimes there's just karma, man. All right. Folks, we are now way off track because of the delay and everything. I'm gonna give my staff a break. So I'm gonna give my staff a break. We will start up as soon as we possibly can. And the like. All right. Thank you. If they weren't copied.
All right.
Thank you, Judge.
I had a case in Somerset when I was on the other side. I had a case in Somerset. So
The landlord's attorney actually admits she's being reasonable. That's rare. Think this case will end peacefully or blow up later?
It is.
Carbonell on behalf of Mr. Bell.
Gregory, please take your name for the record.
Good morning, Your Honor. Gregory Bell, or good afternoon, Your Honor. Gregory Bell approaching for the defense.
All right.
Well,
I
former
now
attorney
have
judges
a
will have
plea
it.
form that indicates that what I had indicated before, probation and may seek prosecutor deferred with the case being final completion of probation. All right, very good. Okay. Okay, I have it sworn.
Do you solemnly swear or affirm the testimony you're about to go truth and nothing but the truth so be on?
Yes, ma'am.
Lower your hand and state your name again.
Gregory Allen Bell.
Sir, it is this court's understanding that you're going to plead guilty to the charge of failure to return rental property $200 or more, $200 or more, but less than $1,000. That is a misdemeanor punishable by up to 1 year. Oh,
I'm sorry. Look at the
equipment.
thank you.
There's too much noise behind me. Thank you, Your Honor.
Not a problem, sir. Good.
No, there's a lot of static.
No, you may not have it turned on.
Oops, sorry. It's on.
Yeah, that's better.
Can you hear it?
Yeah, that's too high.
Okay, sure. I'll let you just.
Got it?
Yes, sir.
All right. Form indicates that you're going to plead guilty to the charge of failure to return rental property $200 or more, but less than $1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property not returned. If that's greater than $2,000, that would be the maximum fine. Do you understand that?
Yes, sir.
All right. I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
That's my understanding too, Your Honor.
All right, very good. Understanding all of that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding those rights?
None, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date or between the dates of March 12th, 2024 and March 20th, 2024, location at 2714 Washtenaw Avenue in Pittsfield or in Ypsilanti Township, Washtenaw County, State of Michigan. Did you rent some property?
I did, Your Honor.
What'd you rent?
A truck.
All right. And did you return that property?
No, Your Honor.
All right. And you would agree that the place that was supposed to get, they were supposed to get the truck back?
Correct.
All right. And that you did not return it to them?
Correct.
All right. And that the value of that truck, although it's a Dodge, is in excess of $200?
I would suspect so, Your Honor.
Okay, very good. Counsel?
Defense is satisfied. Fine.
Well, let me ask you this and let me advise you of this, sir. I do have to advise you that if you commit misconduct between the time that I accept your plea and the time of your sentencing, you would not be allowed to withdraw your plea. And also, any sentence evaluation or agreement, the court would no longer be bound by you.
I understand that, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Judge. It's Douglas.
Oh, not aware of any other promises.
Okay. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
Thank you, Your Honor.
Thank you. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
September 11th at 10 a.m.
September 11, 2025, 10 a.m. That is before Judge Washington. Bonds will continue. Thank you.
Thank you, Judge.
Okay, Your Honor, I've been doing urine samples through the VA hospital because I knew that was kind of part of the protocol. Do I turn that in to you or give?
No, you turn it into, I turn it into 14B probation.
Okay, thank you, Your Honor.
Thank you. Court does call the cases of the people versus the Marianne Markowski Smith.
Who has been here all morning, but I don't see him in the courtroom now. We may briefly pass the matter. I'll go find him.
Court calls the case of the people versus Elizabeth Hill.
If you ever show me this book, you
Good afternoon, Your Honor. Edward Lucas on behalf of Elizabeth Hill.
Hello. What's your name?
Elizabeth Hill.
All right.
Your Honor, today's time and date for our PCC. I'm asking for an adjournment today. I have a motion up in circuit court on September. What date is that? September 2nd, and that could assist with resolving this case. So I'd be asking for an adjournment possibly
after that date.
After that date.
Probable cause conference, September 11, 2025. 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. Court calls case of the people versus Kenaya Johnson.
Good afternoon, everyone. Wendy Barnwell, P42505, on behalf of Miss Kenaya Johnson.
Ms. Johnson, can you state your name, please?
Kenaya Johnson.
Thank you. What are we doing?
Your Honor, I'm asking for another PCC in this matter. I was just assigned this case yesterday. I've spoken to the prosecutor who was in court this morning. I saw him this morning and we talked about this. We're trying to see if we can resolve this prior to any movement, Judge. Right. So we're asking for another PCC.
This will be adjourned without objection September 4th, 2025, 9 a.m. All right, bond continued.
Judge.
Thank you.
And my clients also Zoom then, Judge.
You can fill out the form, Ms. Bardwell. You can fill out the form and send it in and we'll consider it.
Thank you, Judge.
Thank you.
Have a good day,
Court calls the case, People versus Michael Laster.
Good afternoon, Your Honor. Good to see you as always. Robert Ellman with and on behalf of Mr. Laster.
State your name, sir. Michael Laster. Thank you.
Your Honor, you should have a green sheet in front of you there. I was just appointed on this matter, so I'd be asking for an adjournment for time to obtain and review discovery.
Probable cause conference, August 28th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Ms. Foster.
Have a good
Court calls case of the People versus Emily Bates.
Ready, Judge?
Andrew Childers appearing on behalf of the people.
Portia Feaster, Assistant Public Defender, on behalf of Miss Emily Bates, who appears to be on Zoom again, Your Honor.
Yes, she's on Zoom. And can you unmute and state your name?
Hello, Your Honor. How are you today? My name is Emily Bates. Hello.
I'm doing just fine. Thank you.
Good to see you
Judge.
again. Thank you.
My understanding is that Miss Bates is in a treatment facility. We were awaiting her to send us some information, proof of her treatment to provide to the prosecutor. We have not yet received that information. I would ask for another couple-week adjournment and ask that Miss Bates please send that over to our office as soon as possible.
Okay, you got that, Miss Bates?
I do, and just for the record, I am in a shelter right now with with very good treatment and treatment options, and I have a lot to convey to the courts about this. I was wondering if it would be possible that I could kind of tell my story to
not today, ma'am.
Okay.
You can call our office.
My question is, does it have to be in writing if I send something, or would you prefer a typed a countenance?
I'd prefer that what you do is communicate with your attorney and they'll instruct you as to what you should do with reference to communicating with the court. Okay?
So I'll call Mr.
Yes. Feaster.
Attorney. Thank you, Feaster. Sorry, sir. Thank you. It's nice to see you as well. Thank you for your help and for representing me.
Thank you.
Thank you, gentlemen.
Thank you.
August 28th.
Thank you. Thank you very much, Judge.
Thank you, Your Honor. Thank you.
Hey. August 28th, 2025, 9 a.m. Bond continued. Court calls case People versus Donald Foreman.
Good afternoon, Your Honor. Roy Gagne, Assistant Public Defender, with and on behalf of Ms. Foreman. All right, Mr. Foreman, can you state your name for the court?
Donald Foreman. Thank you.
Your Honor, I submitted a green sheet. Hopefully, we're requesting a brief adjournment in this matter.
For discovery.
Yes, Your Honor.
August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you, sir. Court calls case of the People versus Darius Grady.
Thank you, Judge.
Good afternoon, Your Honor. Amy Riser on behalf of Diesel.
Portia Feaster, Assistant Public Defender, on behalf of Mr. Grady. Please state your name for the record, sir.
Darius Grady.
Thank you, Judge. I spoke to my client and to Ms. Riser on email. My understanding is there is an offer on this file, but it's different from the offer in our notes. So I need to talk to
Try to
Mr. Grady.
rectify what exactly it is. Probable cause conference will be adjourned August 28th, 2025, 9 a.m.
Thank you very much, Judge.
Bond continued. Thank you.
Thank you.
Court calls case People versus Suzette Hampton.
Good afternoon, Your Honor. Raymond Cook for the People.
Anna Mackey on behalf of Mrs. Hampton, who is approaching.
Suzette Hampton.
Your name?
Suzette Hampton.
Thank you. And you need an adjournment because you got to check through GIS, which they tried to take away from everybody.
Yes, Your Honor. Normally, I would have had that information to confirm.
Otherwise, you would have been able to proceed today. in the expeditious fashion that the public defender normally does.
That's correct, Your Honor.
Forces out there that tried to hamper that, both you and the prosecutor's office. It's a darn shame. I'm not standing for that injustice, so I'll adjourn this.
Thank you, Your Honor.
The probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond.
May I just bond real quick, Your Honor?
Bond?
Condition. Ms. Ham,
She's free.
but not to leave the state.
But she wants to leave the state?
For
She doesn't like Michigan?
well, she's chaperoning a youth trip for her church on this weekend, August 9th in Ohio. Right here. You wanted proof?
So, am I really going to stop Miss Hampton from taking a bunch of youth on a
Via Temple
trip
Church
to Ohio?
I would hope not.
Okay, so what dates is she?
It's going to be this weekend, Your Honor, August 9.
Just for one day, or is it just one? Okay. I will indicate defendant may travel to Ohio on the 9th of August. Not a problem. All right. Bond will continue in all other aspects.
Thank you, Your Honor.
Thank you, ma'am. Points to the brochure, like I can see that. Court calls the case, People versus Robert Harris.
If you were to make that before the people.
Assistant Public Defender Alexis Durf with on behalf of Mr. Harris, who's approaching. Mr. Harris, can you state your name for the record?
Robert Harris. All right, thank you.
Your Honor, you should have a green sheet. We're requesting an adjournment.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir. Court calls case of the People versus Hiram Haywood.
Andrew Toby, the on behalf of the people.
Assistant Public Defender Dobbie Lieb on behalf of Mr. Haywood, who is approaching. And Your Honor, Mr. Haywood will be executing an examination waiver.
Waiving?
Yes, Your Honor, with an understanding that he will be in the drug treatment court program.
All right. You need to take your hands out of your pockets, sir.
Could you just sign it? Just to confirm that you're waiving your right to an exam and you're going to.
Mr. Haywood, you're waiving your right to preliminary examination? Yes, sir. You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed. Yes. You understand you will not have that hearing. You'll proceed to circuit court for further resolution. Yes. You understand? Okay. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of the information. We acknowledge receipt of the information. We will waive formal reading and enter and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 25th at 1:30 with Judge Slay.
September 25th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls the case of the People versus Dalton Howard.
And then I have the people, Your Honor.
Stephanie Cannon on behalf of Mr. Howard, who is approaching, Your Honor. Mr. Howard, when you're present, please state your name for.
Dalton Howard.
Your Honor, I did check. I did not receive the discovery that I requested the last time we were here. So I'm just looking for a bit of discovery in this matter. And it was emailed the last time we were up for court. I'm sorry, because I left my computer. But I will re-forward the email to the attorney and to, what is it, AD Discovery,
And
whatever
Your
it
Honor, I
is.
did put in a request on the 18th for looking at it. I'm not sure.
What happened? All right. Adjourning to September 4th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Serrano Johnson.
Assistant Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Serrano Johnson. How are you, sir? I'm good, sir. Better, I hope. Indeed. Okay.
Your Honor, we're asking for an adjournment in this case, potential referral to sobriety court.
Okay. All right. So you don't have the referral up here at this point, but you're.
No, I just need to discuss a
working on
bit
that
more.
process.
Yes, thank
Okay.
you.
All right. Very good. So probable cause conference, I'll adjourn it to September 4th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. Take care, sir. Court calls case people versus Stephen Johnston.
Lord Yagi, Assistant Public Defender with and on behalf of Mr. Johnson. Mr. Johnson, can you state your name for the court?
Yes, I see Stephen Johnson.
Stephen Michael Johnson.
Okay, you need to turn on your camera. All right, what are we doing?
I'm looking to figure out how to do that.
Okay, Your Honor, I submitted a green sheet. I would be requesting an adjournment.
Can you verify as best you can that that's Mr.
Oh, yeah.
Oh, there he is.
There he
Got him now. Okay. So he's headed to Bear River now, or?
That was my understanding, is he's headed to Bear River.
Is that correct, Mr. Johnson? I can't hear you. You're muted.
Yes, Your Honor.
Okay, you're headed up there. Okay. I will adjourn the probable cause conference to September 4th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the people versus Alexander Cronin.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the people.
And Lord Yagi, Assistant Public Defender with and on behalf of Mr. Cronin. Mr. Cronin, could you state your name for the court?
Good afternoon, Your Honor. Good to see you again. My name is Alexander Cronin. How are you?
Good. I'm doing well. He's waiving exam.
Yes, Your Honor.
Sir, you're waiving your right to preliminary examination?
That is right, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I do understand that, and I do wish to waive it.
All right. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do understand.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following. Ms. Young.
Your Honor, we acknowledge receipt and waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to all 3 counts. Court will enter a not guilty plea. Pretrial will be set for
September 30th at 1:30 with Judge Cutty.
September 30th, 2025, 1:30, Judge Conkey. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Enjoy the rest of your day.
You do the same. Court calls case People versus Sandra Law.
Good afternoon, Your Honor. Raymond Cook with People.
Stephanie Can on behalf of Ms. Law, Your Honor. But Ms. Law, but not with Ms. Law, Your Honor.
She's actually on.
Oh, is she on Zoom? Great.
Yes, she's on Zoom. Ms. Law, can you state your name, please?
Sandra Law.
Do we need video, Your Honor?
Yeah, go ahead.
Ms. Law, the court needs video. You have to show yourself.
Can you see me now?
Yes, we can see you.
Okay.
Okay. You're requesting an adjournment?
Yes, Your Honor.
All right. There is an issue with her community corrections. She's testing elsewhere, so I'd investigate that before we get a violation out of that.
And Your Honor, yes, I'm going to prepare a stipulated order to get over to the prosecutor to allow her to test where she's testing at. I've asked that she just text me with that information. Once I get that information, I'm just going to prepare a stipulated order to allow her to test where she's at. So she is.
Proper cause conference will be adjourned September 4th, 2025, 9 a.m. per adjourned invite.
Thank you, Your Honor.
Thank you. Thank you, Ms. Law. Court calls case people versus Juan Lamaster.
Okay, Rachel McGuffey for the people.
Matthew Mansour, Assistant Public Defender. On behalf of Mr. Lamaster, who is approaching, state your name for the judge whenever you're ready.
My name is Karan Lamaster.
Thank you.
Thank you, Your Honor. There should be a green sheet. We're requesting an adjournment. We've received an offer. We just need a short time to consider.
Cause conference will be adjourned August 28th, 2025, 9 a.m.
9 a.m.
Or as your invite indicates, bond continue. Just keep in contact with your attorney. They'll tell you what block you're in, so you're not here all day.
Gotcha.
All right.
Thank you.
Thanks,
Thank you. Court calls the case of the people versus Jeremy McGee.
Alexander, on behalf of the people, Your Honor. Assistant Public Defender, like on behalf of Mr. McGee. Mr. McGee, can you please state your name for the record?
Jeremy McGee.
Your Honor,
Of course.
you
Go
should
ahead.
have a green sheet. We are requesting an adjournment. I believe that the videos have made their way over. We just need some time to review those.
September 4th, 2025, 9 a.m. Or as your invite indicates, bond continued.
Thank you, Your Honor.
Court calls case of people versus Anthony Mangiarstina.
APA Rachel McGuffey for the people.
I think I left a syllable out.
Assistant Public Defender Davi Leba on behalf of Mr. Mangarasiana.
You said that perfectly, but you don't have a client.
He's coming, Your Honor. And I don't know that I said it perfectly.
Oh, there he is. Okay.
I'm innocent.
Yes.
False accusation.
Okay, Mr. That is his position, and we are setting it for preliminary examination, Your
You
Honor.
want it set for preliminary exam?
Yeah.
I'm not a thief.
Mr. Mangarasiana,
Sir?
please stop talking.
Sir, no. You'll have your time to challenge the charges made against you. Now is not the time to do it, and not in the manner in which you are doing. Am I understood? No? I'll tell you what. I think I can make it so that you understand me. This is not a game.
Mr. Mangarasiana, please tell the judge that you understand him.
I understand you.
Counsel, your discovery is complete.
Yes, it is, Your Honor.
People have their witnesses available on the 19th.
We will try our best, Your Honor.
Preliminary examination in person will be set on August 19th, 2025, 9 a.m. before Judge Moore. Bond at this time will continue. Thank you.
Thank you, Your Honor.
Court calls the case people versus Jeremy Massa.
That is for the people.
And Maggie on behalf of Mr. Mazza, who's appearing on Zoom.
He needs to step behind the bar.
Mr. Mazza, can you please state your name?
Hello, I'm here. Jeremy Meza.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond continued.
Thank you.
All right. Thank you, Mr. Mason.
Thank you, Your Honor.
Court does call the case of the people versus Patrick McGee.
Assistant Public Defender, on behalf of Mr. McGee. Please state your name for the record.
Patrick McGee.
Thank you.
Your Honor, we are requesting an adjournment. We are waiting on some videos. It's my understanding that they've been requested from AAPD. They just haven't received
They
them
haven't
yet.
gotten over. Probable cause conference, I'll adjourn September 4th. You need to take your hands out of your pockets. September 4th, 2025, 9 a.m. or you're invited. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Jordan Miller.
Jennifer Douglas for the people.
And I can be behalf of Mr. Miller. Approaching, Your Honor. For the record.
Jordan Miller. You need an adjournment for.
We're awaiting some video discovery that was received by the prosecutor's office last night.
Probable cause conference will be adjourned September 4th, 2025, 9 a.m. or if you're invited, case bond continue. Thank you, Ron.
Thank you.
Court calls the case of the People versus Lanish Mitchell.
Douglas for the people.
Hannah Mack on behalf of Mrs. Mitchell, who is approaching to my right.
Lanish Mitchell.
Your Honor, the people would move to dismiss this case. I did submit the motion for all of us.
We have no objections to that.
You have no objections?
Absolutely none.
What about you? No? Didn't think you would. Ma'am, this case is dismissed. That's by Nellie Pross. All right. Take care.
Thank you, Your Honor.
Does call the case of the People versus Megan Moses.
Attorney Judge Torshell seeks to assist the public defender on behalf of Ms. Moses, who I believe is on Zoom, Your Honor.
Thank you for calling Language Line Solutions. This is
That's not Ms.
Marion Williams.
That's me. That's me. Hello?
Okay, Ms. Moses, I need a camera. Oh, there you are.
Yes,
State your name. All right, I see Miss Moses. All right, what are we doing?
Thank you, Judge. I do have a green sheet, Your Honor. We had previously adjourned this case so could make payments to try to get this matter resolved in her benefit. She has been unable to make those payments. I'm requesting an adjournment so I can discuss with the prosecutor other potential resolutions.
She's receiving benefits of some type or trying to?
I think so, Your Honor. But I don't know that she's received them and she hasn't made any payments. And so if she's unable to make those payments, then the offer that was discussed, I'm sure won't happen. So I need to re-engage the prosecutor to see where we go from here.
August 28th, 2025, 9 a.m. bond continues.
Thank you very much, Judge.
Thank you.
Your Honor,
Yes.
this
Ooh.
is your Spanish interpreter on the line.
Yes, ma'am. Hold on one moment. I'm just trying to clear some other cases. We'll get to that case in just a moment.
Okay, perfect.
Court calls the case People versus Bryant Murphy.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Chelsea Virgils with and on behalf of Bryant Murphy. State your name.
Bryant Murphy. Thank you. All right, you're requesting an adjournment.
Yes, to continue our plea discussion, and we have yet to receive media discovery.
September 4th, 2025, 9 a.m. or your invite indicates bond will continue. All right, thank you, sir.
Thank you, Your Honor.
Yes, no, I'll do the Spanish. Oh, you're coming down, right? Let me just try this then. Court recalls the case of the People versus Demarion Markowski Smith.
People.
Well,
Riddell.
Oh, I'm sorry, Judge. Calvin on behalf of. You say your name for the record?
The landlord's attorney actually admits she's being reasonable. That's rare. Think this case will end peacefully or blow up later?